Okay, I will talk about the presumption under Section 4 of the Evidence Act. The term presumptions refers to an affirmative or non-affirmative elation pertaining to a doubtful fact or proposition and drawn by following a process of probable reasoning from something substantive. The presumption is a legal or factual assumption drawn from the existence of certain fact. The presumption raised under a statute has only on a evidentiary value. The presumption drawn in respect of one fact may be an evidence even for the purpose of drawing presumption under another. M.S. Narayan Menon alias Money versus State of Kerala reported in 6 Supreme Court cases, page 39. Section 4 of the Evidence Act 1872 enunciate the law presumption. It defines may presume, shall presume, and conclusive proof. May presume means whenever it is provided by this act that the court may presume a fact, it may either regard such fact as proved unless and until it is disproved. Shall presume means whenever it is directly by this act to be conclusive proof of another, the court shall, on proof of one fact, regard the other fact as proved and shall not allow evidence to be given for the purpose of. Shall presume means whenever it is directed this act to be conclusive proof of another, the court shall, on a proof of one fact, regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. Evidence Act declare a fact as a final and conclusive. Its impact is a crucial because no party can then give a evidence for the purpose of disproving that fact. This is substantive section 4, which defines three kinds of presumption. It is dealt with in Calcutta Municipal Corporation versus Pawan Kumar. The case is reported in Manu Patra, Supreme Court, page 11, 1999. AIR 1919, Supreme Court, 738. Conclusive proof means when one fact declared by this act to be conclusive proof of another, the court shall, on a proof of the one fact, regard the other proved and shall not allow evidence to be given for the purpose of disproving it. The section provides for non-rebuttal presumption. This is presumption which are conclusive in nature. Now coming to section 5, the evidence may be given on facts in issue and relevant facts. Now section 5, now section 3 says that one fact is relevant to another when one is connected with the other in any of the ways referred to in this chapter. Relevancy is thus fully explained in section 6 to 11. This section enumerated specifically the different instances of the connection between cause and effect which occur most frequently in judicial proceeding. They are designed or they are designately worded very widely and in such a way as to overlap each other. Thus, a motive for the fact in issue is dealt with in section 8, is a part of its cause in section 7. Subsequent conduct influenced by it is dealt with in section 8, is a part its effect is given in section 7. Fact relevant under section 11 would in most cases be relevant under other section. The object of this section is to restrict the investigation made by the court within the bounds prescribed by the general convenience. The principle laid down, no fact can be evidence be given unless it is either a fact in issue or one declared relevant under the following sections. Thus, evidence of all collateral fact which are incapable of affording any reasonable presumption as to the principal matter in dispute is excluded to save the public time. Where the entire evidence of eyewitness was not accepted by the High Court, it was held by the Supreme Court that the accused cannot be convicted for an offence under Section 302 IPC merely on the basis of post-mortem report. The post-mortem report should in corroboration with the evidence of eyewitness and cannot be an evidence sufficient to reach the conclusion for convicting the accused. The scope of this section excludes everything not covered by the purview of some other succeeding sections. The last 4 words of the section, "and of no other," precludes a party from proving any fact not in issue or not declared relevant by any of the remaining section of this chapter. To establish relevancy of any fact, it must be shown that it is a fact in issue or a fact such as declared to be relevant. Evidence is to be confined strictly to the issue. The relevant facts are all those facts which are in the eyes of law so connected with or related to the fact in issue that they render the latter probable or improbable. The section excludes everything which is not covered by the purview of some other section which follows in the statute. There must be specific provision before the fact can be treated as a relevant, and the fact must show that it is admissible under someone or other of the following section. The words "and of no others" impliedly impose a duty on the court to exclude evidence of irrelevant fact, irrespective of objection by the parties. In criminal proceeding, this duty expressly imposed by the Code of Criminal Procedure under Section 298. Admissibility of evidence is while the services of sniffer dog may be taken for the purpose of investigation. Its faculties cannot be taken as evidence for the purpose of establishing the guilt of an accused. The explanation appended to the section prohibits a party from claiming any relief upon the facts or documents not stated or referred by him in his pleading. Now coming to doctrine of res gestae. Res gestae is a Latin term which can roughly be translated to things done, but actually was originally used by the Romans, which means acts done or actus. The concept of res gestae has emerged from the belief that the certain acts or statements which may otherwise be irrelevant and inadmissible may be admitted as evidence due to the very situation in which they were committed or altered. The doctrine of res gestae is generally used to admit potentially inadmissible piece of evidence in order to provide context to an event. Important principle of this doctrine is that all the facts must be described in the same transaction. The doctrine of res gestae is expressed under Section 6 of the Evidence Act of 1972 in the following words: "The fact which, though not in issue, are so connected with the facts in issue so as to form a part of the same transaction, are relevant whether they occurred at the same time and a place or at different time and a places. Now coming to the important judgment on this issue, the Krishna Kumar Malik versus State of Haryana 2011 7 Supreme Court cases 130. The Supreme Court held that the doctrine of res gesta is an exception to the rule of hearsay evidence. It further observed that for a statement to be admissible under Section 6 of the Evidence Act, it must be made contemporaneously with the act or immediately thereafter. In another case, Gentila Vijayavardhan Rao versus State of Andhra Pradesh, it is reported in 6 Supreme Court cases 241, wherein the Supreme Court held that where there was a significant time lapse between occurrence of the event and recording of a statement of an injured victim by the magistrate, it was held that the statement under 6 of the Evidence Act. In another case, Bishna versus State of West Bengal, AIR 2006, Supreme Court 302. In this case, Honorable Supreme Court held that when the witnesses arrived at the places of occurrence immediately after the completion of the event and heard full account of what had happened, their testimony was considered valid under Section 6 of the Evidence Act. It is essential to note here that only statement of the fact can form up a res gesta and not a statement of opinion. Then another case in Sukhar versus State of Uttar Pradesh, 9 Supreme Court cases 507. In this case, the victim tried to alarm that the accused will shoot him in a few minutes. On hearing the alarm, witnesses almost reached the place of incident. However, the victim survived and the accused was charged under Section 307 of the IPC. Despite the circumstances in this case being hearsay evidence, but still the court recognized the act in the same part of the transaction and explained to be case of Section 6 of the Indian Evidence Act. Therefore, statement of the witnesses was admissible as it formed a part of same transaction. Now coming to the facts forming part of the same transaction under Section 6. This section admits those facts the admissibility of which comes under the technical expression res gesta, that is, the thing done, including the word spoken in the course of a transaction, but such fact must form a part of the same transaction. If the facts form a part of the transaction which is the subject of inquiry, manifestly evidence of them ought not to be excluded. The statement as that of illustration A is relevant only if it is that a person who has seen the actual occurrence and who uttered simultaneously with the incident or so soon thereafter as to make it reasonably certain that the speaker is still under the stress of the excitement caused by his having seen the incident. The statement uttered or the act must be spontaneous reaction of the person witnessing the crime and forming part of the transaction. The bystander's declaration must relate only to that which came under their observation. The declaration must be substantially contemporaneous with the fact and not merely the narration of a prior event. Applying this to the facts of the case before it, in which the witnesses rushed to the scene of the crime on hearing the sound of the explosion and heard from the mouth of the bystanders as to what had happened. The Kerala High Court has held that statement was not a part of the transaction. This aspect of a doctrine was applied by the Supreme Court in Ratan Singh versus State of Himachal Pradesh. The accused intruded into the courtyard of the victim's house at night and inflicted gunshot injury on her. She was able to identify him. She stated before her death that the accused was standing with the gun before her. She explained the time and the space proximity between her and the assailant. The statement was held to be part of the transaction and relevant as such under section 6. The eyewitness spontaneously told the person reaching the place immediately after the occurrence that the accused killed the deceased. Such person derived knowledge about the incident spontaneously with the happening from the eyewitness. Their evidence was held to be relevant under section 6 as forming part of the same transaction. A transaction in its ordinary sense in some business or dealing which is carried on or transacted between two or more persons. Now coming to case laws, R versus Chrisley. In that case, what has happened? They were charged with indecent assault on 5-year-old boy. Shortly after the assault, the boy and his mother came to the accused, and the boy told his mother, "Mom, this is the man." The evidence of the statement of the boy identifying the accused was admitted as forming the part of the same transaction, but evidence of the boy explanation of the assault was rejected as a hearsay evidence. In another case, R versus Bedingfield. Here, a woman with cut throat came running out of a house. She was crying continuously but did not say a word about how the injury was caused. However, as soon as her aunt came, she told her, "Oh aunt, see what Bedingfield has done to me." Cockburn Chief Justice delivered the judgment explaining such statement in order that they may be admissible as a res gestae should be contemporaneous with the transaction in issue, so as to give no time opportunity for concoction or fabrication. The statement should not amount to mere past occurrence.